रेकॉर्डिंग स्टार्ट करा नाही.
हा झाली ना. मी येऊ का वर आता?
या या.
क्या बोलूं सर मैसेज मानेगा ना ग्रुप बी का ए आए सर मेरा नहीं बड़ा शेड है इसमें ज्यादा सर मेरा नहीं जानता आई नो नेम आमच्या ऑफिस जवळ अक्षरशः आम्ही तिथे जातो तुम्हाला बोललोय पेमेंट द्यायचं सर मी बिंदूला बोललो ना मी नसले तर मी सांगतो आपण अरे तू बॉम्बे वेळ सोड नका बरं 2 मिनिटात काम मला द्यायचं तुम्ही डेप्युटी आहात तुम्ही पण डेप्युटी 5 मिनिट मला सांगितलं की सर इज नॉट अवेलेबल देयर नो वन मला हे झालं नाही तर बिंदू मॅडम मी सांगितलं आहे वाटते सामने जायचं तर शेअर करा पण ते कॉन्टेक्स्ट नव्हतंच आहे ना नाही तर हा नाही का म्हणतोय आमच्याकडे इंग्लिश आम्ही सांगितलं तुमच्यावर झाला बोललं पाहिजे आज चालेल अजूनच हा करून मी असं काय काम बाकी कुठे अरे काय वाटतं एवढेच जण आहेत आपण क्लासरूम मध्ये बसलो How many are here from fourth year? We are not sending any recording. First of all. So inform your classmates that recording available. They are not coming here. They are expected that you should be there in offline. Convenient interpretations we don't follow. एक सेक्शन आलं ना पाच 6 मिनिट पूर्ण बसतो तेव्हा तुम्ही तुमचं पुढे बोलून ना कार्यस्थळ पुढे बोल काहीच मीच काम नाही थिएटर में बैठे का आप या पुलिस रोक दिया ठीक है लैपटॉप होगा हाँ है ना नहीं नका ऑल दोन वर काय प्रॉब्लेम आपल्याला की I will meet him at वो अभी तक आया नहीं स्टूडेंट्स आर नॉट हियर तो उनको नीचे
Sir, when will we have that? Because this is a
ये बात तो कर देंगे you have a lecture at 1 who's lecture यही है these guys are expert in consider this to be an 1 to 2 is everybody knows it will Ramni know this Ramni 1 p.m. do you have a class whose class
1 to 3 we have
family no but it is आपके स्मार्ट हो जाते आप ये चीजें कितनी ज्यादा है
सर आम्ही सेपरेट करायला मागतो
डाउनलोड
डबल होते
880
सकाळी आले सर
मी एक मेल पाठवलाय मराठी 2 मीटर 30 एचएस in one video we'll just put the name of the
आता आम्हाला डेडलाईन पर्यंत सगळ्यांना दिलेली होती सो दॅट वी कंप्लीट
well update it is lately as there on the group
सो एकदा फोटो काढून
Another 60 I have just right now. Oh, you missed my class today. I just saw you. It's coming in 5 minutes. It's coming in 5 minutes. कुठे आहे दादा? Guest house.
माझी एक फ्रेंड आहे ती कोकणीवरती आरटी आहे सब्जेक्ट त्याला मी नेक्स्ट वीक बोलून
या एनजीओचे डिटेल्स आहे ना आपण त्याचे कोलॅबरेट करू.
actual main and 100 students are there. That's like a part-time job. Sort of part-time job. So I have a US company, so I work as म्हणजे $12 म्हणजे per class 300. रोजगार बघ आता मी एक सेवा सगळं घेऊ शकतो की गोल बॅग्स करायचं पण काय डेव्हलपमेंट डिस्कशन प्रपोजल पण तयार आहे. सो आता मी थांबायला गेले तर कसं
सर
behind us. This is the two blunders here. Wonderful.
Okay.
ऐसे करो ना.
You want a mobile mic? Yeah. No problem. Mobile mic. चालत बोलायचं सामायिक
श्रीनाथ सर माईक चालू आहे का?
हा, no problem. Name of your book also. Yeah, I have used this for this law and justice course. It's one of the best books. I know last year. We had sent sample copy for Dr. Wilker, and then they are asking, and
A very good hello. A very good morning to one and all present here. I welcome you to this special guest lecture on the subject International Law and Global Skill. At the outset, let me extend a warm welcome to our resource person, Advocate Anil Malhotra. He has attained Bachelor's of Science and Bachelor's of Law degrees from Punjab University, Chandigarh, and an LLM degree from University of London. He studied comparative family law at London School of Economics, besides law and society at schools of Oriental and African Studies. Well conserved with independently conducting civil services, company, matrimonial, and allied litigations at High Court over India and Supreme Court. From 1986 to 1992, he taught civil procedural law and matrimonial remedies for 6 years as a part-time lecturer and a faculty of law in Punjab University, Chandigarh. Worked at High Court as additional central government standing counsel from 1997 to 2000. Have represented a substantial number of private clients for past over 3 decades by filing and defending independent petition at Supreme Court / High Court and other forums in matter relating to constitutional, civil, company, criminal, consumer, and family dispute litigation. He rendered substantial assistance as amicus curiae with reported judgments on two various issues of public law importance. Have represented Government of Punjab pro bono as counsel in defending bias of Punjab Travel Professionals, Regulation Act 2012, at the High Court from 2013 to 2018. For over 37 years, he continues to act as an Indian expert to render reports in foreign courts on appointment by bench in overseas jurisdiction. This is a very impressive resume, sir. Before we go ahead, I would like to extend our gratitude to our resource person for today. I would like to request our Deputy Director, Professor Kshitij Naikade, to kindly felicitate our guest with the token of our love and appreciation.
do a formal felicitation. Token of appreciation.
With this, let me welcome Advocate Anil Malhotra to deliver his lecture on international law and global skills. Sir, please.
A very good morning to you all. Now, I'm going to talk to you on international family law and issues pertaining to international family law. Now, I have been a practitioner for almost 38 years, and this is an area of work in which I dabble with professionally. And hello, yeah. And this is an area of work in which whatever I do professionally, it comes out as a book after 2 years. Now, this is for you as people trained in law. A new vista, a new area of work altogether. From conventional law work, which you will find in law firms, law courts. As I look at it in today's times, we are getting into a highly specialized area of practice or work. International family law is one poor country cousin who has now been adopted by the world and has been elevated to a status of such liberating demands that you as learning skills can innovate, create, and find another constitution for issues, problems, and human-related predicaments which arise. Now, before I come down to the nitty-gritties, I have a book, I have 9 books. My ninth book is called Global Indian in the Law. Why do I call it global Indians? We are 1.4 billion in number. We are living in China. 30 million Indian Muslims live in 400 countries abroad. We have 3.28 million square kilometers with 29 states and almost 7 union territories, 9 union territories. We are huge. For me, going advice going to a foreign country. I don't know the language, I don't know the habits, I don't know the culture. Same is when I go to Tamil Nadu. Because people talk in Malayalam or people talk in Kannada. So just imagine for a foreigner. So I have in my book identified broadly. My book is in 7 parts. I talk of, in the first part, on nationality, overseas citizenship issues, Indian citizenship, stateless persons, Indian passports, and citizenship, then dual foreigners, Indian foreigners with dual citizenship. Then part 2 of the book is marriage divorce. And marriage is divorce, domicile in India. Then matrimonial remedies when parties are residing in India or abroad. Then ingredients of domestic violence. Then perspective of domicile, perspective of domestic violence, and other laws affecting the family. Part of the book is maintenance in matrimonial matters, temporary maintenance, financial remedies to Hindu wife, maintenance for residents, non-residents. There is enforcement of foreign orders, foreign judgments, matrimonial matters. Then we come with part 4. So part 4 is guardianship and adoption. And we look at law in relation to child removal, child custody and guardianship, issues and challenges in India. Then we look at child custody orders and the Domestic Violence Act. Then we talk of adoption, child custody and guardianship, reconciliation of Indian guardianship orders. Then we talk of enforcement of foreign court orders and safeguards. Then we talk of adoptions, Hama and intercountry adoptions. Then we talk of guardianships and adoptions. Part 5 of the book talks about surrogacy of foreign persons, unmarried persons, a challenge. Part 6 talks of law, will, succession. Part 7 of the book talks of anti-suit injunctions, diplomats. And the last part is real justice in virtual courts. So now giving you a bird's eye view This is not academic or fictional work. These are human problems. These are problems created out of movement of Indians who have acquired foreign passports and have started living in abroad in different jurisdictions. You know, the best narration I can give you is by giving you instances of what is going on. Just to narrate few instances. Let me give you a very offbeat example, which you put me on TED Talks. There is a Buddhist lady whose parents and siblings left work. But there was a colony in Bangalore. So there were 9 siblings. The youngest of them proved to be a prodigy. She was sponsored and she went abroad for very good education. She went to England, worked very hard, became a banker. But something went wrong and she went astray. She lost her balance, she became a derelict, she started using drugs, and she lost focus. She was impregnated by a British alcoholic and she gave birth to a child on the streets. Now, in most European countries, whenever a child of such a situation comes forth, the child support services, the local council, and a host of other people step in immediately. So the child was taken over by the Social Security and was put in foster care. But they wanted to know what to do with the child. So they traced her family to the encampment in Bangalore and they put it to the family. What can they do about it? Now, fortunately, she had a sister living in Bangalore who was a doctor, and her husband was also a veterinary doctor. They said, we'll take the child. But then the issue was, what is the legal way to sort out the child? They said, we will get a British guardianship order and send the child here. I said, your British guardianship order will not work. Because in India, we follow the best interest in welfare of the child principle. An independent court will adjudicate the best interest in welfare in India. It would work. So then, after some thinking, and the child, by the way, because of the mother, had a British name, father and mother being British citizens, the child was entitled to a British nationality. So this is a child of Tibetan heritage with British nationality, born in Britain, but to be rehabilitated in India. All of you have read the Hindu Marriage Act. Can anybody give me a solution? Can anybody rack his brain and think of something? Anybody? Oh, you guys should be smart, India.
So we had this case of Saunders Gopal with the Saunders Rajni, in which like the Hindu Marriage Act had this extraterritorial.
You see, let us leave that out. That won't come in. That's a beautiful answer. But it's a very good answer to a question where it doesn't fit in. Now, let me give you the answer. The child is Buddhist by religion. So if the child is Buddhist by religion, the child is Hindu by religion. So if the child is Hindu by religion, the child can be taken in adoption by whom? The Masi, the mother sister. And for that, you don't need anything great. Can anybody tell me how does adoption take place under Hindu law? Anybody? Oh, you guys have forgotten laws. Do you need to go to court? Do you need to write a deed? Anybody? Sad story. Under the Hindu Adoption and Maintenance Act, all you have to do is give the child to the adoptive parents. The natural parents give to the adoptive parents. You don't even need to do Datta Homan, the ceremony prescribed, and that's all. And the moment you do it, the adoption is irreversible. You can write a deed, you can go to the court, but it's not necessary. So I said very simple. Let the adoptive parents go to England and formally under Hindu law, they take the child in adoption. They can go and do some paperwork in the Indian High Commission in London, or maybe record a deed and get it registered so that the child can come out. That was the solution. Let me give you another example. I was in England in June, and on my way I got a query about the same-sex relationship of a Dutch and an Italian woman who had an 8-year-old child procreated through surrogacy. The Italian mother had led the womb, the Dutch mother had given the ova, and the sperm donor was an anonymous person. Sounds like a film story. Every day, life brings you a new story. So, the mother, the Dutch mother, who had contributed the ova, had given genetic baby. So she was recorded as the mother on the birth certificate, and there was no father. Obviously, you can't have two mothers. Now the child became a point of contention between the two ladies, and the Italian woman fled with the child from India. So after moving around into different countries, she landed in Goa. So they asked me, what do we do? I said, you give me questions. I told the British lawyers, you give me questions, I'll answer them. You know, I was shocked. They told me, we don't even know what to ask you. I said, then how do you expect me to help you? So anyway, I did the right questions and we zeroed down on questions. And I told them that a habeas corpus writ based on a British court order seeking the return of the child is the way we can get the child out. Now, let me give you another totally contrast example. There's also a problem of returning children back to India or rehabilitating children in India when children are in need of care and protection. A North Indian gentleman married to an English white lady who was a supplier of drugs and also a prostitute. That man fathered 3 children through her, and he used to pay for it. Now, these are very real horror stories, but this is reality. Now, the 3 children were a witness to everything what was going on in the house, which meant drugs, which meant prostitution, which meant solicitation. In England, you can solicit officially. So they took the children into foster homes, but they realized that they can't keep the 3 children apart, their siblings. So they decided to rehabilitate the children. Now, the father's sister in Punjab decided to take on the children. So through a mechanism of a court order, we brought them here, and she applied, or she attempted to apply for becoming a guardian because his natural parents are still alive. But the boy had grown up so much that after 3 months she realized that this boy is becoming a problem for her 2 daughters. because he had started making advances. Child went back. So what I am trying to give you this vast scenario, say, when you get into this area of work, you may have to start at the family code level, but get into it. This is an interesting area. It may not be money making for the timing, but when you grow, then things change. Now then is also the question of child abduction among parents. Now let me put you in the international scenario. In India, interparental child removal is not considered a wrong. So when a parent removes a child from one country to another country, nothing goes wrong. We are a signatory to the Hague Convention on Child Abduction. We are not a signatory. 110 countries have signed it. So whenever there is a domestic dispute, one parent brings a child and comes to India. The other parent comes with a foreign court order and seeks its enforcement. We follow the best interest principle, and our Supreme Court normally tends to say, we will send the child back to the jurisdiction which has the closest contact. And in this process, the child can go back. But since we have no law made by statute, we keep doing a flip-flop. Now the question is, if one invokes the wrong remedy, which is a current ongoing matter which I am doing in the Kerala High Court, and in parallel in the London High Court, where I have been in touch with lawyers since yesterday, 3 days past, and today morning. There is a hearing in London and there is a moved and retained by the wife, twin boys, about 6 years old, in Kerala. The man was wrongly advised to file a petition under the Guardian and Wards Act for seeking their custody and guardianship in Kerala. He was not advised that Section 9 of the Guardian and Wards Act doesn't make the court have jurisdiction because the children don't ordinarily reside there. But he's made the petition, rightly or wrongly. Now I told him, you Friday. See, we are 5 hours behind. If it is 5 o'clock there, it is 10 o'clock here. So today they have a hearing in London, but the judge in London wants to know, why should I act when a guardianship court is already looking at me? So I told them, you tell the judge that jurisdiction was wrongly invoked. We are now going to take an order from this court in London, and we are going to enforce it in the High Court of Kerala in a habeas corpus writ. And we will be withdrawing this petition in the family court with leave and liberty to pursue this. Now, it's very complex, but then you have to guide the whole thing. Fortunately, doing it online has helped a lot. COVID has taught us a lot of things. Our High Court is not very user-friendly in hybrid modes. Most courts are, and things have changed. I'm also doing another very interesting matter in Kerala, again virtually, through a lawyer there. Couple married in South India, both IT people moved to Bangkok, then they shift to Germany. From Germany, they settle down, they have a 6-year-old boy. The lady is also working. The man on one day, without any notice, without any intimation, picks up his son, goes to his native place in Bangalore. Mother is horrified. Where is she gone? She gets in touch with him. He says, I'm not coming back. He's living in his brother's house, a small house. Now the husband is very smart. We complain to the police, we complain to the Human Rights Commission, the Child Rights Commission, but nobody does anything. Now the man appears before the police station, makes a complaint that my wife is having multiple affairs. So I have moved out. He also makes his son speak the same thing before a child welfare committee. So I told the lady, I said, unless you file a writ of habeas corpus, nothing will happen. So we get a German court order and we move the High Court of Karnataka in Bangalore for a writ of habeas corpus of the German child. The day the petition is listed, he appears to lawyer. Matter is put off for 2 days. On the next day, the lawyer comes and makes a statement that the client and the child have gone to Bangkok. Now, ordinarily, a judge would say, child is gone, I can't do anything. But I told the senior lawyer appearing, I said, put me on. I told the court, I said, when the court took notice, the child was here. A statement was made before the Child Welfare Committee. So the child has been removed from the jurisdiction of the court to frustrate the adjudication process by the court. And in a habeas corpus, the High Court exercises parents' pecuniary jurisdiction. The best, the High Court is the guardian of the child. The child has to be brought back. The matter has been argued. The husband has been told to bring the child back. So you need to catch up, apply your mind, and find a solution to the situation created whenever the situation arises. But take the extreme example of surrogacy. Of course, there is a new law in 2022 by which everything is stopped. But we had from 1995 till about 2010, there were guidelines of a wing of the Ministry of Health and Family Welfare. So these guidelines permitted surrogacy to everybody. So what happened? In the process, surrogacy went on uncontrolled in India. Gujarat, Maharashtra became hubs of surrogacy. There is a place called Anand in Gujarat, which has baby farms, huge hospitals, where you can hire a womb, you can hire anything, and you could have got a child. So India became a hub for surrogacy. So same-sex couples started coming. But law also created peculiar situations. Maybe Manji Yamda's case, Justice Arijit Sai's statement is reported. He has used very harsh words. Why? Now, when Imiko Yamada, the lady whose daughter came to with her husband for surrogacy, her daughter and the man were married. But when the child was born, they were divorced. So India said we can't give the child to a father because she's a girl child and Indian laws do not permit so. So the father brought Miko Yamada, his mother, to take control of baby Manji Yamada by a petition filed in the Supreme Court. And this because of the situation. Now, this was an ad hoc, out of the box solution, engineered by Supreme Court. Likewise, John Balaz. Now, a German couple did a surrogacy in Gujarat through a surrogate mother. Genetic material was theirs. When the child was born, the Gujarat government gave a birth certificate with the surrogate mother's name on the birth certificate and said the child will get an Indian passport. So the government of India said this is nonsense. This is a foreign national. You can't be given the matter went to Supreme Court. Justice Gogoi framed 13 questions. But will we wait for those? Will the children wait for those 13 questions to be decided? No. Same thing. The children were given exit permits and told to leave the country. And John Bilal's case is still gathering dust in the records of the Supreme Court. Another very interesting situation, Baby Emperor's case. Now, this is a child born to a Jamaican woman and an American man. Now, the lady brings the embryo, fertilized embryo, in a cryogenic jar from America. Why? Because her husband has aerophobia. He can't sit in the flight. She, of her own, has contributed nothing because the ovum donor is an anonymous person. So she comes to Ahmedabad and she finds a surrogate and the child is Baby Emperor is born. He has a long name like all African people have. So she went to the passport officer and said, I need a passport and I need an exit permit. He said, we have to do a DNA. Every embassy or everybody does a DNA. She said, you can't do a DNA. I have not talked to you. Then he says, we can't entertain you. She kept going to him every day. One fine day, that Jamaican woman kept the baby on his table and said, you keep the baby, I'm going. In 24 hours, she got an exit permit and she left. So, what is the problem? We have got problems, we have got issues, we have got predicaments, we have got into things which time has created, but we have not evolved laws. We have a Guardian and What's Act of 1890. Our Hindu Marriage Act is of 1955. The Hindu Adoption and Maintenance Act is 1956. So over a period of time, we have not changed our laws. People have changed. Our migration to different countries has multiplied. We are very busy changing commercial laws because they get money. But in the realm of family law, we do nothing. We are changing the names of all our acts with Hindi names, which I don't think anybody can remember. Oh, why don't we write an 1890 Act, the Guardian of What's Act? Why don't we change it? There is a brilliant report number 257 of the Law Commission by Justice Abhisha, amending the whole thing. Nobody looks at it. It's a colonial thing. Now, let me give you another update on things going wrong. Inter-country adoptions. Now, under Hindu law, Hindus can adopt under Hama by a process of giving and taking, as I told you. So, what do Hindus do? They give and take, and it's over. You take a relative's child. Now, in comes the Juvenile Justice Act 2015, under which we have CARA, Central Adoption Resource Authority. It was an agency, now it is an authority. We have signed the Adoption Convention, the Convention of Adoption in 1993. Now, because of that convention, we have a system in place, happily and luckily. So anybody who wishes to adopt a child from any country, registers in the country wherever he is, they, depending on his seniority, list him for his proposal being sent to India. If he wants to, he or she, they want a child from India, and then India matches, and then the child is given, and the process is taken. So CARA and JJ Act were a secular law made in 2015 to incorporate the Hague Convention of Adoptions. Now, just for information, whenever we sign an instrument, a convention, or a foreign legislation, we accede to it. But to accede to it, we first have to make a change in our domestic law. And then we sign and accede to it. So we made all the changes, we made the adoption regulations. Now, in the process of making the adoption regulations, CARA, as a statutory body with no legal heads, no legal inputs, has gone so far that they have taken over the adoption matter also. How? Now, any child who has to leave the country after adoption may be an orphan, abandoned, or surrendered child under CARA, under JJ Act, or a Hindu child under Hindu adoptions, needs that certificate from CARA. In orphan, abandoned, and surrendered children, it is a NOC from CARA, but in other cases, it's a conformity certificate. Meaning, CARA certifies that the adoption is in conformity. Now, for your understanding, JJ Act is a secular law. Hindu Adoption and Maintenance Act is a religion. Where he says Muslims, Christians, Parsis, Jews, Hindus, whoever they are, with Shabnam Hashmi, 2015 SSC 1. Anybody can adopt under the JJ Act. But if I am a Hindu and I just want to do the ceremony and take a child, I'm exempt. I don't have to go to CARA. I can do the process. I can do the formalities. Go to CARA and say, please give me a conformity. What is happening now? CARA is becoming a law unto itself. I assisted the Punjab and Haryana court in a matter called Jasmine College reported judgment. When he done said CARA has no role in this. Issue a conformity certificate and let the child go. Then BSK, a judgment by Justice Pratibha Singh in Delhi, said you better make a system to devise Hindu adoptions. This is all haywire. Now CARA amended its regulation in 2022 and it has brought into its fold all Hindu adoption laws, saying you do whatever you like, but you will have to follow the procedure under the adoption regulation. So where does Hama go? Section 56(3) of the JJ Act says that notwithstanding anything in any other law, the Hindu Adoption and Maintenance Act shall be intact. Now, I have a peculiar case in the Punjab and Haryana court ongoing. Baby born on 1st of December 2021 to a Sikh couple. Now, a close relative of the family, also a Sikh couple in the US, come and adopt the child, do an adoption ceremony, do a registered deed, also follow the process of CARA, apply to the district magistrate. Now, there is another thing which has happened, which now all adoptions under any law are to be approved by a court. Court means judicial court. Court means a family court or a guardian judge or a judicial court. The JJ Act has been amended, and wherever the word court exists, it has been replaced by a word called magistrate, which effectively means that an executive magistrate can perform the judicial function of a court and certify an adoption. And this is absolutely crazy. They have only amended the JJ Act, but they have not amended HAMA. They have not amended the Guardian and Wards Act. Now, this couple is waiting since 2021. They have two daughters, 13 and 16. The man is staying with the baby boy, now 1.5-year-old, whom they have adopted. He can't return the child. Adoption is irreversible. The lady has gone back to her other daughter in the US because you don't know how long it's going to take. So he came to me for a solution. I said, what we will do, we will not seek the writ of mandamus. You all know what a writ of mandamus is, Constitution. We will impugn the constitutionality and the vires. You understand vires? The legal tenability of law. We will challenge the vires of the adoption regulations, and we will challenge the vires of the passport guidelines. Because now the passport officer is also saying, I'm not going to give you a passport till you get a NOC from Kara. They've got a birth certificate, they've got an Aadhaar card, they've got an adoption deed. He says, I don't care. Now, there are 13 grounds under which a passport can be denied. Kara NOC is not one of them. But in the guidelines on filling of forms, this has been incorporated. So I have challenged the constitutional validity and the vires of the provisions of the Passports Act and the adoption regulations, saying they are against right to life of the child to live with his parents. They are also constitutionally against the right to family life and the right of life guaranteed by Article 21, right to life and personal liberty. No person shall be deprived of his life and personal liberty except in procedure established in accordance with law. Life, look at the word life. You can expound it to no end. Right to marry, right to procreate, right to live in the same sex relations, anything. Now the court has issued notice, but that was the only way. My Chief Justice tells me, you've done an excellent job. Kara is becoming a law unto itself. They have taken over the eruptions. Why don't you also challenge the definition amendment of court to magistrate? So I told him, my lord, I am not a researcher or an academic. I just want to leave the country. This, if I challenge the values of that thing, it will take years. Either you give me, as was done in the previous matter, either you give me a passport and you give me a conformity certificate, leave me, and we look for the values of cases of better ways. So you also have to realize that the man who's paying you, he's not interested in the values. He's only interested in what you can get in and how fast you can get. So I told him, I said, we aim for the sky, we fell off the roof. So I told the Additional Solicitor General who appeared to accept notice. I told the Chief Justice, please suggest to him to take instructions whether I can leave the country with the passport and the child. Because the family is apart. And I can't return the child. Say, oh, thank you very much. I'm sorry, you can't take the child. Because Kara is now saying, listen, you go back to US and register where you are living under the adoption agencies in that country. And when your turn comes, we will match you with a child in India. So I haven't bought a wrong plane ticket that I can say you are deboarded, catch the next flight. We are dealing with human beings. So this is a bad, nobody realized that Kara has become a law and rules. I've written a very hard-hitting piece on this. Can Kara abrogate, can Kara abrogate to itself the right to decide everything? Can it take away the powers of judicial courts? Can Kara decide that it is the final authority. And by the way, in Kara there is no judicial input. The chief justice asked me who heads Kara. I said last I heard was the captain Sanjay Kumar, retired army officer. Now imagine a body equipped with quasi-judicial functions. Quasi-judicial means semi-judicial, but no legal inputs, no judicial inputs. So what has Kara become? The chief justice said, I tell you what Kara has become. Man, a foreign couple, white couple steps on into a plane, brings up an agent in Kara and says, I'm coming in, I want a child. Child is rustled up, he comes, does the process, Kara has control, then he's out in 3 months. But for a price, which he pays on. So are we back to trafficking of children, which was the position in before Lakshmikant Pandey 1, 2, and 3 judgments from the Supreme Court by which we overhauled the law of adoption to Indian children as far as it's all about. So this is another challenge. Now I am tired and exhausted, and I want you to ask questions. So who starts with the first question? Yeah. Legitimacy of children who are see. See, I tell you, very good question. Suppose you adopt an orphan, abandoned, or a surrendered child. Now, so please pardon me. Don't use the word illegitimate. It's wrong to use it anymore. Good. Now, under law, whatever process you adopt a child, the child severs all relationship with the natural family, gives up all property rights, inheritance rights in that family, and becomes the so-called adopted child of the adoptive family and acquires all rights acquired by virtue of adoption. So he automatically gets to have a passport, a birth certificate, an Aadhaar card with the name of his adoptive parents, and all rights. In the case which I just narrated to you, he is the brother of the 2 sisters, and he has no relationship with his siblings in the natural family. So the law is very clear: sever, irreversible. You go back historically, adoptions are in our mythology, and even amongst Hindu philosophy, when you go into death, moksha, when you hit the head with a stick at the time of cremation to release the atma, was done by sons, adopted sons. So this is so ingrained in our philosophy that we have believed of it since time immemorial. Relationship severs, no illegitimacy. Next. Front row. No questions? Yeah.
I had a question related to marriage. Which is that if polygamy is constitutionally still valid in India, why is it not allowed under states?
Polygamy. I'm not talking about polyandry. You should say polygamy and polyandry. See, you may have something which is permissible by custom, maybe in the northeast or certain states. But under the Hindu Marriage Act, if you are married, you cannot enter into another relationship, because the precondition is that you are not married. So you will not be able to enter into second marriage even under the Hindu Marriage Act. You may have live-ins, 1, 2, 3, 4, 5, any number, no problem. But marriage would be a no-no. But it's an interesting question. I went into the depth of this. So when people in old times had multiple relationships, say in Gujarat. In Gujarat, they used to do a maitri karar. No marriage, but a documentation to confer rights on the second companion, so to say. You also have a domestic relationship defined under the Domestic Violence Act. So a relationship in the nature of marriage may get recognition, may get you benefits. But if you go and tell a court, I've already got a spouse and I've got a living, I think you probably get kicked out. It won't work. So don't try it. I hope the question is hypothetical. Yes.
What if a foreign couple living in a live-in relationship wants to have a surrogate baby in India?
No chance. See, till we pass the Act of 2021, everything was on. Same sex, unmarried, everything was on. But now under the new law, the surrogacy law, it has to be Indians, it has to be 5 years of marriage, and it has to be a failed. You need an infertility certificate. Just imagine telling a woman you are infertile. Can you do it? But the law is so absurd. So you at most they will let you have surrogacy if you are a married couple of Indian origin and foreign nationalities. But foreign nationals out of the window. But now a very good question. This is Parliament made law, no foreigners. But when we come to the Juvenile Justice Care or Protection of Children Act 2015, you can adopt a child, a person can adopt a child. Word used is person. In surrogacy, the word used is citizens. Adoption is permissible to a person, irrespective of marital status, with the only exception that a man cannot adopt a female child. Now look at the way the law looks. Surrogacy, no. Adoption, yes. What is the ultimate aim? Parenthood. Two different routes, but two different routes to the same goal, but with different conditions. I don't think it's constitutionally valid. But this is how lawmakers make the law. The thinking on surrogacy has gone a different way because of religious beliefs. In European countries also it is no, the church does not allow it. The only place where it is flourishing is Georgia, US. It was booming in Ukraine. Then came the war. 500 babies were born during the war. They were all in underground bunkers with mothers looking after. So the parents couldn't come in to claim them. And you had to do a genetic test to take them away. What happened to them, I don't know. Did Putin take them? You know, I don't know. That guy first. Yeah, go on.
So, for example, and there is an Indian couple who are in a living. So, and
Things have gone far.
yes, sir.
Things have gone far. I'm not talking about you. So,
I'm just saying.
Hindus, see, if you are Hindus, go under Hammam. But then people may ask you, are you married? Religion is different. So you cannot take under Hama. Once you are a non-Hindu, you are out of Hama. So you have to go to Kara. So you have to go to Kara, wait for your turn, register, wait for your turn. Because there, the word used is adoption shall be available to persons irrespective of marriage status. So there is a lot of hope. Don't worry. Okay.
So the concept of Maitri that we discussed in Gujarat. So effectively, it
You are
is.
from Gujarat?
No, I'm not.
I thought you have a case to narrate. You said, I know somebody who was there.
No, sir, I'm from Punjab only.
Oh, okay. In Punjab, we don't have it. We have it, but we don't. We said there is nothing required. Unofficially, we do.
Sir, so effectively, the second wife becomes like a concubine. So
Oh, sir. Pardon me. Don't use that word, sir. You know, these girls in this room will tear you apart. Say companion. I have in Punjabi, I have a better word, but I'll tell you outside. Let us not get into crude things. Say companion.
yes.
Or say partner. In England, you have the civil partnership act.
Yes.
Partner. You know, there is a messy in white. It doesn't say spouse. It says me and partner. I don't have any other partner except my wife. So anyway.
So what are her rights under the same? Like it is all governed by custom. So what would be her rights apart from the?
You're talking about live-in.
No, I am talking about the arrangement in Gujarat.
See, I think if you are living in with a married man, your chances of getting anything are very poor. At best, you can come out and say he raped me, and then get whatever you want. Because the moment you charge that man with rape, 376, and get an FIR, you will get whatever you want. That is the lawyer's way. Yes, next.
Will it not help like if anyone gets if anyone chooses to convert to then this practice will it not enable them in
So you are saying a person converts to Hinduism, then does adoption, and this will help trafficking.
would it help in trafficking like
You see, let me tell you, converting to Hinduism is very difficult. There is nothing prescribed. It's a very gray area. Now, I give you an instance. When I was before the Chief Justice, he spent half an hour rubbing me down. Who are they? How are they related? You know, he tells me, are they Hindus by religion? They are Sikhs. I say, my God, they are the definition is all inclusive. What is their relationship? What did they do? Where do they live? He ran me for half an hour. And then he changed the questions. He knew everything. He had read the question cover to cover and he gave the big lecture to the National Solicitor General on the nonsense which Kara is doing. And since he's got a case, what was he trying to do? He was trying to break me down. He was trying to interrogate me on the adoption. I said, you can see that man sitting there with a beard. And he's mothering the child with his 13-year-old daughter. He said, what do we do? He said, in Punjabi, he said, Chiki kariye. What do I do? I can't leave the child. So if you start doing things like this, you get into trouble soon. Somebody reports you, you'll be in for traffic. So I don't think this is something which will increase traffic. But I think what is going wrong is the taking away the courts. From ruling on adoptions. I was going backwards. When they had started doing this amendment in 2017, I was invited to the Judicial Academy in Bhopal. There, the director told me that the Chief Justice, India Justice here, has Meka Gandhi, the Women and Child Development Minister, after saying adoption are going very slow. This is not deciding cases. So we had a very big workshop in Bhopal. There all these bureaucrats came and they used charts and graphs and said, "Iski disposal बहुत कम है, इतनी effective, they're not deciding." Then they came out with their drafts that we have drafted this. We are going to simplify this. We are going to appoint district magistrate. So the judges said, then why don't we make a draft order also in the regulations? Simplify. So I think simplifying the process and leaving it more into hands of Kara and executive. You go to a district magistrate, you apply for a gun license, you apply for an NOC for a property, you apply for permission to hold a marriage. It's basically a permission or a license. How do you go about it? The best way is you go to a tout, or you go to a clerk, or you go to a small-time lawyer who works there. And you pay him some money and he gets it for you in 24 hours. Is this what we can do for children? No. So this is going to prevent trafficking. Catch the bull by the horns, not the tail. Yes. Anybody? No.
My question is related to the law. I want to ask you, is there a viable nexus between humanitarian and refugee law as it stands now?
Slowly. Between
humanitarian and refugee law
humanitarian and refugee law.
and the field of international family law, as you mentioned.
Wonderful question. I tell you, I know a lot about what were the two words you used initially? Humanitarian refugee. Now, who are refugees? Rohingyas, stateless persons, Tibetans, illegal immigrants. I drafted the Punjab Prevention of Human Smuggling Act in Punjab. We have a lot of illegal immigrations. People go abroad through the donkey route. The donkey route is walking. You know it. So you go via Greece, via Spain, via Italy, then you walk through the desert, then you go on a boat, then you go under a lorry, you do things, then you do weird things. Or latest thing that's happening with others, you jump over the Mexican border. And sometimes two people fall this side and two people fall that side. It's happening. It's crazy. Or their dead bodies found in frozen snow. Now, all these people who go illegally without passports ultimately become refugees. And in turbulent times in Punjab, people used to claim asylum. It doesn't happen anymore. Now, humanitarian law works to an extent which is working. Now, look at what England is doing. They have decided to put all the illegal immigrants in a boat and keep them on the water. Is that an answer? No. Or send them to Rwanda. Crazy. Most European countries, small countries, Sweden, then Holland, very, very small countries. They find scores of people. They keep them in. Then after 2 months, they just release them back. They say, no place. What do? We don't know money. Why should we feed them? We have started bringing them back also. Now, if there is a genuine refugee, there is a method of humanitarian law coming to their rescue through, let us say, the European Code of Human Rights in Strasbourg, right to life, bigger picture. But those are individual cases. Following a community case is difficult. We have a typical case of in India, Tibetans. Over 5 lakhs of them came with Dalai Lama in 1964 or 65. And I have written on it, are Tibetan Indian nationals? Now, the answer to your question is, a Tibetan born to Tibetan parents in India, post coming here, are they entitled to an Indian passport? Yes. Delhi High Court is ruled. So this is a process of a life. What is that child's fault? And is he going to go back to Tibet? No. The Chinese will kill him. So I think this is more of an adjustment of a country by rehabilitation. Not the Soviet way in Afghanistan or the American way in Vietnam. Annihilate, demolish, kill, finish. There has to be a logical ground. But United Nations bodies are slowly losing controls because nobody listens. So I think a domestic policy has to take care of refugees, but not at the cost of burdening their own system. England has collapsed financially. They can't beat illegal immigrants. They can't handle it. And we as Indians had a bad habit, particularly in North India. We would go there, become Indian citizens, British citizens, take the dole. Dole is that unemployment allowance for 6 months. Then bring all those pounds sterling in India, job, and drink black label, move in taxis, and say, I live in England. This is what we do. So you can't abuse this status, but it happens. So unless and until there is a very genuine case, there is genocide, or there is killing. Suppose people decide to do something tomorrow, maybe yes. Yeah, sure.
So so this genuine fear of persecution, which is required in most cases when one seeks refuge. So the social stigma around a same-sex couple or a person belonging to the LGBTQI+ community, would that be a valid ground for seeking refuge or an asylum in another country? Let's say a country like India, where
I will be very happy to answer that question for a settled fee outside chambers. Seriously. You see, I think this can be a very good ground, seeking protection. It's a very novel way of misusing the law. So you start making bogus same-sex relationships. Say we are facing persecution in Punjab. We'll be stoned to death in UP. So please give us permits to live in Sweden. And once you stand in Sweden, both of you marry a female and say, thank you very much. Worked out well. You gave me a problem, but I thought of it by twisting the problem. It's a very good case for genuine grounds. But the country has to open you. See, for example, a lot of people got asylum in post-Blue Star in Punjab because they feared persecution and killing. But then it was started to be abused, and then they stopped. So claiming benefits, I think you will require an adjudicated process now. They might say, prove it, establish it, have it tested. And maybe it grows big, somebody takes over. See, you've got a problem, you can go to European Court of Human Rights, right to life, right to family life. Europe. You could even try, you could even try petitioning an Indian court, but that will only give you protection in India. You're right, it's a problem. People do face. But then, in India, the problem is you have Mr. Judge belonging to कैसी शादी है सेम सेक्स ये तो शादी नहीं है आप कौन see as a judge you cannot start putting your morality and your individual thought into your judicial judgment. A person has come, any person is entitled to protection. Now whether he's in a same sex relationship or whether he's a runaway marriage, as long as he's not a minor, he's entitled to protection. If there is genuine fear of persecution, you can't say no. such relationships are outside the scope of marriage institution. So you start writing crack like that in your judgment and you're a high court judge. Then you have gone wrong. So I guess when you have a case, there is a remedy. And this is where an international family law lawyer's thinking will come. You will find a solution out of the box. See, when there is pound sterling or euros rolling you, then the mind works faster. You visualize it as you go by. So the instructions are always important to propel the mind into dynamic thinking, to cull out a solution out of the box. So it's what you have raised: humanitarian law, refugees, and protection. It's a very valid area, but you need very vast thought. You need a very open-minded judge. Yes, next. What time is it? We have time till 1 o'clock? Yes. So who's going to talk? So who's going to give a lecture now? Mine is on. Is this segment to stop? Are you testing? Arjunji, testing 1, 2, 3. Even the mind is discussing. So let's engage in something. There's something wrong here. Am I sitting in the wrong place? No, it's okay. So let us look at a different area of law: marriage and divorce. Now, under Hindu law, when we marry according to a religious ceremony. Registration is optional. So the moment you do Satyapati or Anant Karaj, it's done. But in Tamil Nadu, there is a proviso. I read 2 days ago Tamil Nadu judgment and the Supreme Court order of yesterday. Now, if you are in a relationship, friendly relationship, or I don't know what is the phrase exactly, you can go to a lawyer's chamber, exchange garlands, put on rings, and you're married. This is the Tamil Nadu amendment of Section 7A of the Hindu Marriage Act. Pardon? Pardon? Of Tamil Nadu. Lovely. I think every state should copy it. What do you think? Sure. I'm forgetting the name. It's got a long name, but they got an English name. That symbiotic relationship, friendly relationship. It's on live law. I just read it in the morning. Now, this has given a new input because previously, see, our law firm does investigations for people who marry and want to go abroad. So the person wants to marry abroad, then he has to prove that he's unmarried. Or if a person wants to take a spouse from India to a foreign country, he has to prove that he's married her. So what people do is they get hold of an audience, they get hold of a photographer, they get hold of a priest, and they take pictures. We started noticing that in some cases, all the witnesses, the audience, the priest, the Gurdwara or the temple background was the same. So the embassy started asking us what is going on. So we said these are all fake marriages. So everybody now insists, show us the picture of Saptapati. Show us the picture of an uncovered. So we have to prove the marriage. So once in India you are married and you don't have a marriage certificate, it doesn't matter. I and my wife don't have a marriage certificate. because we are married according to Hindu law. But a lot of people register their marriage under the Special Marriage Act. Under Special Marriage Act, you can marry by two ways. Under Section 5, by registering your marriage and not performing a ceremony and doing civil marriage by going to registrar and notice. The second way of getting married is by registering your marriage celebrated on the forms. Means you go to the registrar and say, I performed my marriage. So I would now like a registration done of this marriage, even though it was done 15 years ago or 20 years ago. So this is registration of a marriage celebrated in other forms. Now the question is, having done this, when we migrate, we go abroad, we decide to divorce. We look for a quick exit. We are Hindus by religion. Now we may have become Americans, Japanese, Australians, Canadians. You may become any nationality, you may be living in any country, but you remain a Hindu by religion. Which means you carry your Hindu law on your backpack wherever you go. It is not excess baggage, it is inbuilt in. So when it comes to divorcing, you walk into a court in US or anywhere in Australia or Europe, you say my marriage is broken down. They'll say, okay, fine. It has broken down irretrievably. We want to resolve it. They will not ask you a second question, they will resolve the marriage. But they will only ask you to settle the matrimonial property issues and settle child custody. They will give you a decree nisi, means a temporary decree, and they will give you a decree absolute when you settle the issues. Now the question is, if a Hindu marriage is dissolved by irretrievable breakdown of marriage, is it a valid decree in India? Does it dissolve your marriage in India? Answer is no. Satya versus Tejas, 1975 Supreme Court said no. These marriages are called limping marriages. You are divorced abroad, but you're still married in India. Why? Because the divorce decree, under what provision of CPC would we test the when foreign decrees? Absolutely, you hit the nail on the head. Section 13 of the CPC. When foreign judgments are recognized or not admissible. So there are 4 or 5 exceptions. It has to be founded on law based in India. It has to be on reasonable principles. It has to be after giving the other party an opportunity of defending it, and so on and so forth. So if it is on a ground which is not recognized by Indian law, it is out. Irretrievable breakdown of marriage is not recognized as a ground of divorce under the Hindu Marriage Act because we have a fault-based divorce theory. We have adultery, desertion, cruelty, leprosy, so on, so and so forth. We also have divorce by mutual consent, which is a peaceful way to resolve. So now, what happens? This divorce decree now, when the man wants to settle and pay an alimony or a settlement amount, he wants all the litigation in India to be wrapped. There is a dowry case, there is a maintenance case, there is a domestic violence case, there is child custody case. Will that end? No. So what is the way out? This is where thinking comes in. So I advise people that you bring in your divorce decree in India, you draft a petition for divorce by mutual consent, put that divorce decree of the foreign court as a ground or as material of your having separated, draft another settlement, agree to withdrawing of the cases in India, buy your peace, bury the hatchet, petition jointly in a court where you were married under the Family Courts Act, using the Hindu Marriage Act, Section 13 be divorced by mutual consent and resolve your marriage. This will settle it. If you don't do that and you remarry, you can be caught for bigamy. Polyandry. So, by your status of being single, settle the matter. People say we can't come here. Courts have made it simpler. Our High Court has led the way. Appear online, point a power of attorney to represent you in India. He or she identifies you with your passport for the judge. Likewise, for the other spouse, engage one lawyer or two lawyers. The judge will ask you questions, 3 questions. Have you been staying apart for over a year? Yes. Can you stay together? No. We are already divorced in the US. We want a divorce. The judge will give you a date of 6 months. Or if you are able to tell the judge, listen, it won't work. We are already apart for 10 years, then those 6 months will also be given. Initially, Supreme Court used to use 142. But Supreme Court now says the district judge is supposed to decide this period of relaxation to be dispensable. So having done this, you should be happy to pay your 70,000, 100,000 USD to get reciprocal custody rights and settle the matter in both jurisdictions and be happy to propose and put an end to it. This takes care of criminal cases, FIRs, child custody. Now, once you have an Indian divorce decree, you can move to the High Court for caution of an FIR under Section 482 of the CRPC. Buy your peace in your litigation, because in India, it is punishable under 498. So we can take care of the situation. So this is the best way of resolving Hindu marriages in both jurisdictions. Now, people who don't take proper advice and don't do this regret it. So this is the resolution to the problem I have started telling people. And this is what, whenever a question is put to me, this is the way I answer it. See, for an English, American, Australian judge to figure out, why can't it be resolved by breakdown? It's something which beats his head. Why? In foreign jurisdictions, marriage is a contract. It can be done on asking and it can be broken on asking. In Hindu law, it is a sacrament. It is a religious thing. There's ceremony, it has a halo of sanctity. And why don't we register marriages? Because when we do a public event, I don't know whether any of you will ride a horse or not, but I had to. You go in a procession with all the band, bala and whatnot, jing band. That is registration when people see you in that form. So this is how we marry. Now, for somebody abroad to understand this, impossible. So, when that foreign divorce decree is brought to India, we throw it in the dustbin. But when we try to tell a foreign court, listen, you can't do this, he picks up the argument and throws it in the dustbin. So this is the mindset clash. We don't agree with them, they don't agree with us. We are poles apart of this. See, this is a peculiar problem with the Hindu religion. Muslims are out because they're already contractual. And most of the other people, Christians, Parsis, Jews, they agree to contractual marriage because they don't have such inherent ceremonial issues. Now, this is becoming a very big problem. Now, the next problem which is coming is you are Mr. X, married to Y, when you went in the 50s. When you are divorcing in 2023, you have a yacht, you have a villa in Spain, you have funds in Swiss banks, you have a lot of properties in Punjab or in Goa. So how do you divide the assets? Now, financial division of assets and settling of matrimonial property is a big game for high-end divorces abroad. How do you do it? It's a very difficult thing. And succession. So I tell people, if you are a rich person living in India with properties in India, make two wills, one for Indian, one for India. In England, you pay inheritance tax, which is estate duty, which is no more of law in India. So keep the Indian property out, make a will, register it there, do probate, or sell it or do whatever. So these are laws which divide things into issues, but they are very problematic and work-oriented areas. Okay, I come back to your question.
India, I mean, so how it was fought was it came under the grounds of cruelty. So particularly in that case was mental cruelty. So it was essentially the grounds was used for data knowledge and for mental cruelty. So it was fought under cruelty. Although the term officially wasn't used as yeah, I think it can be one solution, one way to go about it was exactly what you said. But I think another way to look at it was
See, I understand what you say. The ground in the Hindu Marriage Act under Section 13 has treated the respondent with cruelty of an extent, blah, blah, blah. The word is cruelty. The word is not eligible to it. Now you can take cruelty away from Dastani and Dastani to Shailesh versus Sri Chandra and expect, it's a wild goose chase. You can take it to any end. You can say that you can't transplant irritable breakdown with cruelty. Cruelty is the genus. Species is irritable breakdown. You can bring down, water down. You can say that this is the marriage is not so. Now, I find myself at odds on the same level as you. The district judge can't use it to break down. The High Court can't use it. But Supreme Court says we have a magic wand. 142. Everybody knows what 142 is. Anybody doesn't know what 142 is. Raise hands. Ladies in the back, 142. Can anybody tell me about 142? Somebody at the back. Madam, you. The young lady with the glasses. 142 of the Constitution. I'm trying to look at you and you are not trying to look at me. Article 142 of the Constitution. The young lady with the lovely suit. Yeah. No? Your friends, any of your friends? How about you, the gentleman in the glasses? Oh, excellent. Wonderful. Yes, absolutely right. So Article 142 is Supreme Court says that to do complete and effectual justice between parties, they can pass any order They can give any relief, they can do anything. So what Supreme Court does, coming back to you, Supreme Court says the marriage is irretrievably broken down. So Supreme Court says we can do it, you can't do it. So under 142 you have brought in irretrievable breakdown. Now there is a thought process of bringing in irretrievable breakdown. I have myself advocated it in marriages where one of the persons or both of the persons are of foreign nationality. It doesn't work. But you can't bring in irretrievable breakdown to 70% of India, which is underprivileged. It will be abused. So you have to put it with break. You have to have breakdowns, safeguards. You have to have checks and balances. So therefore, it's a good thought process. Supreme Court does it. But I think the better way of doing it is, I think what Supreme Court should do is, they should make people file a divorce by mutual consent petition and stop using the word irretrievable breakdown. Or tell them to go there, or take suo motu notice, treat it as a petition for divorce by mutual consent, record consent of parties and bury the hatchet. So this is something else.
Like in irretrievable breakdown, there is usually one party, especially the wife, who doesn't have the consent. So how the mutual consent principle works?
See, mutual consent only comes in when both of you are agreeable. When one party doesn't agree, then you spend 25 years fighting in courts. You start from the family court, spend 5 years there, then spend 5 years in the High Court, and then spend 7 to 8 years in the Supreme Court. After 20 years, the Supreme Court says this marriage is irretrievably breakdown. So, end of story. So instead of burning your youth, instead of wasting your energy, when people come to me, I handle problem lines everything. The first question I ask him, आगे जाना है कि पीछे जाना है? You want to go forward or you want to move backwards? Those who say we want to go forward, I say let's sort it out. I have seen a brilliant lawyer, Nalini Deshmukh in Bombay, family court lawyer, very elegant, very senior lady. She goes for settlements and she travels to the other side and talks to the settlement. Very open-minded approach. But you also have the likes, unlikes of her in Delhi, no names, who are my opponents and my best friends in cases, ladies 1, 2, 3, 4, 5, feminists. No chance. So it's a different thought process. But where you think children are involved, where you think there are going to be more problems, the sooner you sort it out, the better. Because at the end of the day, after 10 years, 15 years, you will burn down. Lawyers will take your clothes away also. You will be left, right, and center everywhere you go. In Supreme Court, they say even the walls ask for money. It's true. It's an expensive place. You shouldn't think of Supreme Court unless you have 10 lakhs fees. But then sometimes egos come in the way. And in India, there's a bigger problem. The family is not the family, but it is Chachaji, Mammaji, Tayaji, Pupharji, and Masi. You know, there are a host of advisors. All of them say, go on, not a worry, go on, let's fight. So they don't leave you anywhere. Any more questions? Is it 1 o'clock? So can you say goodbye and thank you? Oh, good. It was very interesting. But the better part is you people ask questions. Unless you ask me questions, it's no good. I go to the academy in bar also. So when there is a judge electing the judges, everybody sits like this. But I tell the judges, make 6 tables, have 5 guys each, and let's have an interaction. So they teach me a lot. I learn a lot from them. And they share my knowledge in a different way. So it's very good interacting with you. Think. Always think. Article 14. I read it 10,000 times. No person, Article 14, equality before law and equal protection law. No person shall be deprived of equality before law and equal protection. Article 21. Every person shall be entitled to his right, life and personal liberty. Will not be deprived of life and personal liberty. You accept that process comes from you. Every time you read it, you get a new thought. And when you apply it to a case, you can take it out of the case. Surrogacy, abduction, marriage, divorce, it's your brain. Being a lawyer, all you need is very, very sharp brains. Start as a first generation practitioner. Do whatever you want, advisory work, court work, or working in a law firm. Think differently. My daughter studied at West Bengal University of Political Sciences. Excellent place. There the alumni trained me. She became Aditya Birla Scholar. I didn't spend a penny on her. She interned with Allen and Overy, Magic Law Circle of Firms Group. She's a solicitor there. My son did a BA in Global Affairs from Jindal, a law degree from Jindal. Went to London to do an LLM in the same college where I went, but he went as a Felix scholar. He wants to be a barrister. Thinking. If you start in the little pond in the village, you will remain a Pendadadu, means a frog in the well. But if you go to the Caspian Sea or you go to the Atlantic, you become a whale or a shark. Sky is the limit. On that note, cheers to you.
Thank you.
Thank you, sir, for that session. Was full of knowledge and inspiration. I'm sure our students learned a lot from you, and maybe they will be able to contribute in future with your knowledge and your inspirational words. I thank you again, once again, for your time and your efforts, sir. Thank you.
Everybody, please mark your attendance. The attendance sheets are here for all the batches that are there. Thank you very much.
And when I see Gurpur ma'am, I'm going to say the audience is very good. Please give them five lectures extra. I was a teacher for 6 years. That is, I used to tell everybody, don't want to come, don't come. The door is open, but the door closes after 2 minutes. And nobody will follow our lectures. Actually, lecture business is.
Excuse me, can you please
दिख ही नहीं रहे हो, कहाँ क्या बैठी है?
अनुज मेरे
मैं अब ऐसा पीछे